What is the importance of having a provision for change in the conditions of contract? Or having a clear distribution of risks as well as responsibilities? Or have you ever wondered why there are suspension or termination clauses in the conditions of contract? Welcome to On Silver Screen, where learning is interesting. We are still at the contract practice season, and in this video, I will continue the discussion about the conditions of contract. If you want to see more videos about quantity surveying, please drop a like on this video, and you may share this video to your friends, especially those who are preparing for this APC, or to your friends who has interest in construction industry. And if you haven't done yet, please subscribe to my channel and turn on the notification bell so that you will be notified every time I upload a new video. In the first episode of the series of these videos, I talked about general provisions and parties to the contract in the first installment of this video. And on the second part, I spoke about quality assurance and control, price and payments, as well as time. In this episode, we are going to discuss changes, risk and responsibilities, and suspension and termination that can be found in the provisions of general conditions of contract. Now let's talk about changes. Changes can be defined as any deviation to the original contract description as deduced from the contract documents as a whole, describing or defining the works to be carried out. We all know that changes are almost inevitable in every project. It is therefore important that the conditions of contract provides a clear mechanism on how this inevitable occurrence be handled. What do we mean when we say change mechanism? Change mechanism or variation order mechanism is a part of the contract condition that will dictate how change regime will be implemented, what events will trigger the changes in the contract, and how the impact of these changes be valued. So now, why is the change mechanism important? A construction contract defines the works that the contractor must deliver, and unless it contains provisions to the contrary, neither party is entitled to unilaterally change the scope. So from episode 1, if you remember, of our contract practice season, we learned that the contract is formed when one party made an acceptance to the offer by the other party. The parties are then bound to deliver on their respective part of the contract, and any changes or non-compliance to what was agreed could amount to a breach of contract or the breach of agreement. And the party in breach is liable to compensate the agreed party under the law. So the variation mechanism will allow the employer to order the necessary or desired changes. While the consequence of variation mechanism is to give the contractor the right to additional payment, the principal purpose of the procedure is to alter the contractor's obligation as to what is required to build and without committing a breach of contract. So this is why a change mechanism is important. So in order to avoid the breach of contract, a mechanism to cater for these changes should be in place. Now, if you want to know more about contract law, please visit my previous video, that is Season 3, Episode 1, where I discuss about contract law. What should be included in a change order mechanism? First, there must be a definition of what constitutes a change under the contract and whether such change order or such variation order will have an impact on cost, time, or both. So you noticed here we say whether it should have an impact to cost or time. Isn't it that any change in the contract should have an impact to either time or cost? Well, the answer to that is no, not all changes will have a cost or time impact. Some changes are minor to have an impact. For example, the change in wall paint from one color to another, but using the same type of paint. Well, of course, there are other factors that should be considered whether this type of change will have an impact on cost or time. For example, the timing when the instruction was given, and so on. Next is the authority to order changes. The conditions of contract should clearly establish who has the authority to order the changes. Don't be confused between who can authorize and who can initiate the changes. Changes can be initiated by any stakeholder to a project. It could be the client, the contractor, or even the authorities. But who can authorize to proceed with such changes should be defined in the contract. So mostly, it is the contract administrator who can order the changes to a contract. And the procedure of issuance of instruction to change. The conditions of contract should provide a clear guidance on how the contractor should act once the instruction is given, either written or verbally. This is important in order to provide a traceability, control, and accountability with regards to changes, especially for verbally given instructions. Claim procedure. Procedures for claim for the impact of change should be clearly defined. For example, the notification process. Will there be a time bar requirement? What are the supporting documents required? And so on. Valuation and payment procedures. It is important that both parties are clear on how the impact of the change be valued and be paid to the contractor. Also, remedy for non-compliance. This part of conditions of contract provides the action that can be taken by the client should the contractor fail to comply with the instructed change. One of the reasons why this clause should be provided in the contract is to protect the project's interest in the event that the contractor failed or even refused to comply with the instruction for change in the contract. Let us now talk about risks and responsibilities. To understand risks and responsibilities, first we have to define what is a risk. Risk is a potential event, either internal or external to a project, that if it occurs, may cause the project to fail to meet one or more of its objectives. This section in the conditions of contract will detail how risks are distributed or shared between parties to a contract. It may also provide that the party who took ownership of the risks shall be responsible or indemnify the other party should the particular risk occur. Provisions under this condition of contract may include indemnities. This section provides protection to each party from claims, including those from third parties arising out of execution of the contract works, willful breach or act of negligence by the responsible party. Third-party claims may include damages to existing property, bodily injuries. Also, if the other party, say the contractor, suffers loss or damages due to act of negligence by the employer shall indemnify or compensate the contractor. This is the importance of this clause. Care of the works. This condition will stipulate which party should be responsible for the works and what event shall occur that will transfer the responsibility for care of the works from one party to the other party. For example, the contractor is responsible to take care of the whole of the works, but once taking over certificate is issued, this responsibility will be passed to the client. So this is the importance of this particular clause. Next is employer's risks and its consequences. This section of the conditions of contract will detail the risk event that are under the responsibility of the employer and provides the contractor an avenue to recover any loss that it may suffer due to these risks. Examples of these risks events are force of nature, which are unforeseeable. If the risks event occurs, the contractor may have the right to be compensated in terms of time and cost, provided of course that the contractor follows the claim procedure in place. Limitation of liability. The purpose of this part of conditions of contract is to maintain a reasonable balance between the differing objectives of the parties to a contract, each of whom will wish to limit its own liability whilst being entitled to receive full compensation for the default by the other party. This will also allow the parties to better predict the extent of potential liability and obtain appropriate coverage at a more reasonable cost. So here we talk about coverage. Coverage is usually provided in terms of insurance. The primary purpose of insurance is to ensure that the contractor has the financial capability to execute the works, irrespective of fortuitous loss or damage. Where the risk is allocated to the employer, the insurance should, whenever possible, enable the employer to pay for the rectification of damage caused by the employer's risks. Additionally, if the contractor fails to complete the works, the insurance should enable the employer to pay another contractor to rectify the loss or damage to incomplete works. We will talk more about the common insurance requirement for a construction contract or construction project when we reach the season of risks management, where I will talk about bonds and insurances. Please watch out for that video. Now, let us talk about suspension and termination. This provision in a contract regulates the rights of either or both parties to suspend the works or terminate the contract in defined circumstances. Further actions to be taken with the parties after termination may also be covered in this clause. The following provisions may be included. First, let us talk about suspension. Suspension is a temporary stoppage of works or performance of the contract due to certain defined circumstances. And when suspension to the works is given, the following can be the consequences. First, the contractor will be entitled to compensation if the reason for suspension is not due to its own default. Next is that prolonged suspension of works may lead to termination of the contract. So we mentioned here termination of contract. Let us talk about termination of contract. Termination means the cessation of performance of obligation by parties under the contract. And termination can be due to the following reasons. First, termination due to default. For example, breach of contract, insolvency, suspension, and so on. In termination due to default, a party's right to terminate the contract may originate from the general principles of the contract law, or it may arise out of terms of the contract itself. It is available only in response to the material breach of the contract by the other party. Another reason that the contract can be terminated is termination for convenience. The client can terminate the contract for no reason at all, at its own convenience. The right to terminate for convenience may originate only from the terms of the contract, which provide for such termination, for there is no general contract principle allowing termination for convenience. Another reason is termination by frustration. Frustration is a common law doctrine that a contract will be discharged by frustration if after formation, an event occurs which renders further performance of the contract impossible, illegal, or something different from what was contemplated by the parties when entering into the contract. We will talk more about the principles behind suspension and termination when we reach the season for contract administration. Again, please watch out for that exciting videos. Now, when the effect of termination provides that only the employment of the contractor was terminated and not the contract itself, certain provisions in the contract can still operate, such as the valuation of works done on termination. This provision in a contract provides assurance that the contractor's services will be valued up until the effectivity of the termination of its employment. Payment after termination. This section provides the mechanism for the contractor to be paid after termination of its employment takes effect. And cost recovery. Cost recovery mechanisms allows the employer to recover any overpayment or cost incurred and or to be incurred due to works that appears to be non-compliant to the contract. We must remember that suspension and termination will most likely be followed by claims, which often leads to dispute. It is therefore important that careful consideration should be given in drafting or interpretation of these conditions in the contract. Join me next on Silver Screen when I deliver to you the fourth and final installment of my video about conditions of contract. If you wanted to see more videos about quantity surveying, please support this channel by dropping a like on this video and sharing the video to your friends who have interest in construction industry. And if you haven't done yet, please subscribe to my YouTube channel and turn on the notification bell so that you will be notified every time I upload a new video. Thank you for watching and see you next episode.